afternoon, everybody. There's a bailiff around here somewhere, but anyway, thank y'all.
You want the front row seat?
Please report. I have a quick thank you that North Carolina Mock Trial Program is going to do before we get started this evening. We have had a volunteer with our program that has been one of the most dedicated participants and advocates for this program. And our success as a program counts on those folks in the legal profession, the various bar groups, and head of court, providing that support. Last year, we had our courtroom artist, Erica Oliver, win the state championship. And she went up to nationals representing Sarah. And we were trying to think of ways to thank Chief Justice Newby for all of his support of this program, between presiding for the state finals championship round, as well as volunteering over the last 21 years for our program and advocating for our program as well to help us build it and be successful with it. And last fall, we had Erica make a trip up to the Supreme Court during arguments. And she created a rendering of what she saw in court that day. And we would like to present it to Chief Justice Newby as a thank you.
Let me know who she's going to make remarks about. I'm afraid we'll just not allow her to. Anyway, thank you. Good afternoon, everybody. Congratulations to these two teams. Let's see, we've got the team rosters. I am to remind everyone, please, to silence, turn off all electronic devices. Y'all are experienced, but you know that there's been no communication between the participating team members and others in the courtroom until this trial is concluded. If anyone is in the courtroom not affiliated with either team and present in an approved capacity, volunteer observer, I'm not quite sure how that applies to the finals, but y'all look like you're supposed to be here, so I'm going to check that box. Video cameras, other recording photographic devices are present, confirm that neither team objects. Are there any such devices?
Both teams have agreed to let spectators take videos and pictures, Your Honor.
Okay, thank you. That's helpful. It's now time for me to ask each team to identify its participating members by name and role.
Yes, Your Honor. We are Team K, representing the plaintiff in today's case. I am Daisy Gaither. I will be conducting the opening statement as well as the direct examination of Dakota Stark and the cross-examination of Bailey Parker. And my co-counsel?
Good evening, Your Honor, and members of the jury. My name is Becca Bainbridge, and today I'll be conducting the direct examination of Robin Hill, the cross-examination of Jordan Bannon, as well as delivering the closing argument for the plaintiff.
Good evening, Your Honor, and members of the jury. My name is Jonathan Duckett, and today I'll be conducting the direct examination of Dr. Mills Barton, as well as the cross-examination of Sydney Wilson. And our witnesses?
Good evening, Your Honor, and members of the jury. My name is Brayden Curbo, and I'll be portraying Robin Hill, the friend of the deceased in today's case.
Good evening, Your Honor, and members of the jury. My name is Madeline O'Brien, and today I will be portraying Mills Barton.
Good evening, Your Honor,
Members of the jury, my name is Sydney Hunter, and today I'll be portraying the role of Dakota Stark, the mother of the deceased. And our timekeeper, Your Honor?
Good evening, Your Honor, and members of the jury. My name is Jonathan Hensley, and today I will be timekeeping for the plaintiff.
And with that, Your Honor, the plaintiff just has a few pretrial matters we'd like to discuss, but first, would you like the defense to introduce themselves?
I would like to.
Yes, Your Honor.
Good evening. My name is Blair Miller, and I will be presenting the opening statement for the defense, conducting the direct of Bailey Parker and the cross of Dakota Stark. And now my co-counsel.
Good evening. My name is Ogo Franquito, and I'll be conducting the direct examination of Jordan Banner and the cross-examination of Robin Hill.
Good evening. My name is Iman Nazir. I will be providing the direct examination of Sydney Wilson, the cross-examination of Dr. Mills Barton, and providing the closing arguments for the defense.
And now our witnesses.
Good evening. My name is Emily Swanson, and today I will be portraying Jordan Banner. Good evening. My name is Thea Goldberg, and I will be portraying Bailey Parker.
Good evening. My name is Camila Reyes, and today I will be portraying Sydney Wilson. And now our timekeeper.
Good evening. My name is Gabby Titus, and I'll be acting as the defense timekeeper.
With that, we also have a few preliminary matters.
Yes, Your Honor. First, we'd like to draw the court's attention to stipulation 12, which says Tommy Kirk is not, the watcher in the room where Wade Stark died, is not testifying because he is unavailable and has nothing more to add. Second, we'd like to ask for preferences about moving throughout the well and approaching the witnesses. Would you like us to state for the record that we are doing so, or ask permission? Yes, Your Honor. And finally, we'd just like to draw the court's attention to Henderson v. Bill, which is on page 21 of the case packet, which says that Utopia is a partial comparative negligence state. And while I'm aware that the court has already been briefed on this, I just wanted to make sure Your Honor and the jury is aware of it. Yes, Your Honor. And with that, the plaintiff is ready to proceed.
We just have a few, I apologize. We have a few stipulations to bring to your attention as well. Stipulation 15 states that no equipment repairs or changes were made to the dodgeball zone 13 and up following the decedent's accident. And stipulation 3 states that this case is bifurcated, and the only matter being determined in this trial is liability. Ready to proceed.
Thank you, counsel. Stipulations have been a bit contested, point of contention, I should say. Here is the way I'm hearing both parties talk about the stipulations. I understand that both parties have stipulated as a stipulation. Is that correct?
Yes, Your Honor, that is correct.
Yes, Your Honor.
Thank you. With that, let's see. Okay, Mr. Bailiff, you will, Ms. Bailiff, you will call the calendar and swear in the witnesses.
Yes, Your Honor. This is the case of Dakota Stark versus Springs Park. And witnesses, please stand and raise your right hand. I promise that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition.
I do.
You may return to your seats.
Anything else before we begin?
No, Your Honor.
No, Your Honor.
Thank you. We will hear the opening statement.
Yes, Your Honor, permission to proceed? They forgot, but she remembers. This is Dakota Stark. She remembers April 22nd, 2023 in perfect detail. She remembers her son Wade's face, still flushed from scoring the winning goal at the soccer game that morning. She remembers pulling up into Springs Park's parking lot. She remembers the smile on her son Wade's face. She remembers all of this. Not because of the win, not because of the goal, but because it was the last day of her son's life. Good evening. My name is Daisy Gaither, and I want to introduce you to some people. This is Becca Bainbridge, and this is Jonathan Duckett. And today, the three of us stand here proud to represent the plaintiff in this case, Ms. Dakota Stark. Now, as the plaintiff, we bear the burden of proving that Springs Park's negligence was the direct and proximate cause of Wade Stark's death. Now, the defense, they've claimed a defense of waiver. But as the judge will tell you, in order for that defense to hold up, they had to prove that Dakota Stark was given reasonable amount of time to read that waiver. Burden, they won't meet. And that brings us to April 22nd, 2023. And they forgot. They forgot to do safety checks, their systems failed, and employees just didn't show up. Understaffed and unequipped, they could have closed their doors. But as the evidence will show, they kept taking in more and more children, making more and more money. She remembers. Dakota Stark remembers walking into Springs Park, shocked at the utter chaos. Children everywhere, staff nowhere to be seen. She remembers walking up to the front counter and a rushed employee shoving a waiver in her face, and when she starts to read it, he says, "Look, lady, we don't have time for you to read that." They forgot. The evidence will show that Springs Park's manager, Jordan Banner, the woman right there in the blue shirt, let a 12-year-old boy into a zone meant for teenagers and adults. And not only that, but she went into that zone and she encouraged aggressive behavior. And that brings us to the moment when everything changed. In that zone meant for teenagers and adults, an adult hurled a ball at Wade, hitting him in the shoulder and sending him spiraling towards the edge of the trampoline. Wade's neck met worn padding and metal frame. His spinal cord severed instantly. She remembers. Dakota Stark remembers rushing into that crowded room and kneeling by her son, taking his hand in hers, still warm. She remembers watching his chest rise and fall. And she remembers the sound of his last breath. They forgot, but she remembers. The jury, Springs Parks forgot. They forgot the profit from their joy. You bear a sacred burden to protect them. Today, I want you to make them remember. Fine for the plaintiff. Thank you.
May I proceed? Risk can be mitigated, but not eradicated. Take airplanes as an example. To shoot through the air in a metal capsule is an inherently dangerous activity, but we take enough precautions to make it reasonable. We do things like wear seatbelts, hire trained pilots, and conduct safety checks before every flight to mitigate this risk. We can take every precaution humanly possible to keep everyone safe. But in a second, a bird hits the engine and the plane can still go down. This is an inherent and unpreventable risk of flying. One of many day-to-day activities we partake in where risk can be mitigated, but not eradicated. Today, you're going to hear about another. Sydney Wilson has loved working with kids since she was a teenager. She is also a longtime lover of movement. She will tell you that when she grew up, she asked herself why small-town Meadow Bay Utopia kids shouldn't get the same access to spaces where they could move around and have fun that children in more populated areas have. And that is how Springs Park was born. Sydney opened the West Maple location of Springs Park Trampoline Park in 2015 after putting in all the effort and research that goes into running a safe trampoline park. She will tell you that as a mother of 4 herself, she's a bit of a stickler for safety and following the rules, and this is reflected in her business. She spent serious time making up for the lack of regulations on trampoline parks in the US by keeping herself educated on how to keep her park as safe as possible. She became a member of the International Association of Trampoline Parks before she even opened Springs Park, so she could receive the best recommendations and advisement on how to keep children who chose to come to her trampoline park as safe as was within her power. She will tell you that prioritizing safety, movement, and fun boded well for her in this industry, and she was soon able to provide access to exercise and entertainment to even more children across the county, opening 2 more Springs Park locations within a few years. But one day, disaster struck. On April 22nd, 2023, Sydney received a call from Jordan Banner, the West Maple location manager, saying there had been an accident. Sydney rushed to get to the location as soon as she could to learn that this was like no accident Springs Park had seen before. Wade Stark, a 12-year-old boy, had died. Sydney and the staff at the location devastated. Jordan Banner will tell you that all appropriate protocols were completed following Wade's death, as well as several double checks by her and Sydney of the area where the accident took place. Everything was in order. Springs Park was still doing everything in their power to keep their participants safe while engaging in this activity. But sometimes accidents do happen. We're here today because the plaintiff is accusing Springs Park of negligence. They must prove every element by a preponderance of the evidence, but they will not be able to do so. While we do not hold the burden of proof, we will call 3 witnesses to highlight the truths of the day in question. First, Ms. Jordan Banner, the West Maple location manager, will provide you with a first-hand account of everything that happened that day and present every safety measure taken on April 22nd to eliminate the risk of all preventable issues. Next, Ms. Bailey Parker, an expert in safety and risk assessment and management, will confirm that everything about Springs Park's operations, both on that day and as a whole, were entirely up to code under recommendations from the International Association of Trampoline Parks. And lastly, Ms. Sydney Wilson, the owner of Springs Park, will present to you the love and pride she puts into the safety of her Springs Park locations and go over all protocols and procedures regularly trained and conducted. At the end of today's trial, my co-counsel, Amon Nazir, will come before you and ask you to find Springs Park not liable of negligence leading to the wrongful death of Wade Stark. Because while Springs Park was still doing everything in their power to mitigate risk, it cannot be eradicated.
Yes, Your Honor. The plaintiff calls Robin Hill to the stand. Permission to proceed? Good evening. Could you please introduce yourself to the court?
Hi, my name is Robin Hill.
How old are you, Robin?
I am 14, almost 15.
Where do you go to school?
I am currently a freshman at Blue Point High.
All right, so what brings you to court today?
I used to be a regular at Springs Park. I knew Wade Stark, and I was there the day he died.
All right, now you mentioned that you were a regular at Springs Park. How often would you go?
I used to go there almost every weekend. It was kind of my favorite place.
Why was it your favorite place?
Springs Park was like the teenager version of Chuck E. Cheese, except relaxed and without the adults. Like, imagine if your favorite playground or whatever was run by a bunch of other kids. And to me, that sounds pretty awesome. That was my thinking at the time.
Now, you used the word relaxed. Why is that?
Yeah, it's...
Objection relevance.
May I be heard as that, Your Honor?
Your Honor, the witness is detailing why he got through the park with black in the past. We're here to talk about the accident that happened on April 22nd, and what Springs Park may or may not have done in the past has led.
May I be heard to say, Your Honor? Your Honor, it is our burden as the plaintiff to prove that Springs Park was negligent in running their park. So this evidence that they were relaxed and did not enforce the rules, that would be very relevant to today's case.
Your Honor, if that is true, can I change my objection to improper care of evidence?
Explain that.
Your Honor, if the opposing counsel is using these instances to prove that Springs Park may have acted in a certain way on the day of the incident, that is under Rule 4 improper care of evidence.
May I be heard to say that, Your Honor? Your Honor, we're not offering this to prove action in conformity therewith under Rule 404B, but rather to prove plan and knowledge under Rule 404B2. First, with the knowledge, to prove that the Springs Park employees had knowledge that there were kids breaking the rules, and second, that it was part of their routine practice to ignore that and not enforce the rules. Your Honor, this would be admissible under Rule 404B2.
Your Honor, once again, I would say Rule 404B2 does not say that. Rule 404B2 says that specific instances can be used to make claims of character if that character is essential to the case at hand. Opposing counsel is using these instances of the organization's practices to prove that they acted in accordance on this.
May I be heard to say, Your Honor?
I'm going to go ahead and overrule the objection. I'll allow you to put that on pause.
Yes, Your Honor. All right, so Mr. Hill, could you continue to tell us about how Springs Park was relaxed?
Yeah, it's kind of hard to say because they were all pretty nice to us, but they didn't really do things like check the wristbands or keep kids in the right age zones. And most other places wouldn't let us do things like double bouncing either.
All right, so what sort of age restrictions did they apply?
Like younger kids would go in older areas. The staff saw it, but they didn't do anything
Objection,
about it.
speculation.
May I be heard to say, Your Honor? Your Honor, this is a lay opinion under Rule 701, rationally based on this witness's perception that he perceived that the staff members viewed that the kids were going in the wrong age groups, and yet they still went in there, and that the staff members did nothing about it.
Your Honor, if I may. The witness has laid no foundation as to what he has perceived and is simply standing.
Well, he has said that he was there about every day. I think I'm going to overrule the objection.
Yes, Your Honor. All right, so could you continue with your answer?
So from what I could tell, the staff saw it, but they didn't do anything about it.
All right, so what about supervision in these areas?
Sometimes there would only be one watcher instead of two, and Jordan Banner over there in the blue shirt would tell us to throw harder in dodgeball.
All right, now you mentioned that Jordan would tell you to throw harder. What exactly would Jordan say?
Something like, come on, you can throw harder than that, or let's see who can get the biggest hit.
All right, now I want to talk about April 22nd, 2023. What happened when you first arrived at Springs Park?
I mean, it was crazy. The screens weren't working, you know, the ones that usually show all the rules, and the iPads for the waivers were down.
So what did you do about the waiver?
I just signed it myself.
I'm sorry, you signed it? Were you over 18 at the time?
No, of course not.
So how old were you when you were allowed to sign your own waiver?
I was about 12.
All right, so after you, a 12-year-old, were allowed to sign your own waiver, did anyone verify which rooms you could go in?
No, they gave me a blue wristband. That was for 13 and up.
Did anyone at any point verify your age?
Objection leading.
Your Honor, this witness is free to answer. Your Honor, I'm not asking a question that suggests its own answer, which is the rule under leading. Your Honor, I'm simply asking him whether or not any of the staff members verified his age at any point.
Your Honor, if I may. The opposing counsel is asking a yes or no question, and under Rule 611C, that does fall under the rule.
I think I'm going to again, sorry, I overruled the objection.
Yes, Your Honor. All right, so Mr. Hill, at any point, did anyone verify your age?
They did not.
All right, now let's talk about the dodgeball rooms. But what did you observe there?
there were these really big guys. They were playing really aggressive, throwing at people's heads, which is not allowed, but the one watcher there didn't say anything about it.
I'm sorry, one watcher? To your knowledge, is that normal?
To my knowledge, there's supposed to be two, but
Objection, improper opinion.
May I be heard to say, Your Honor? Your Honor, this witness has testified that he has been to Springs Park almost every day, Your Honor, so this would be a lay opinion, rationally based on his perception that he has viewed that normally there are more than one watcher. Yes, Your Honor. All right, so Mr. Hill, the one watcher that was there, to your knowledge, what was he doing?
just sitting there, staring at his phone.
So what sort of supervision did you see of these college-sized men throwing at children?
Not really any at all, to be honest.
All right, could you tell us what happened during the dodgeball game?
There was this really big guy. He seemed to be targeting Wade the whole time. He would get a ball and just throw at Wade over and over again. You could tell he was getting frustrated because Wade just kept dodging him, but he eventually faked the throw. Wade fell. Wade moved to dodge the ball, and the guy just grinned and absolutely launched it as hard as he could.
Where did the ball hit Wade?
The left shoulder. It completely knocked him off balance.
And what happened when he fell?
His head hit the part of the trampoline that makes the padding strips. There was this crack, and then everything just went silent.
Thank you, Mr. Hill. Your Honor, I have no further questions at this time.
Yes, Your Honor. May I proceed? Good evening. My name is Bogachuda Frankita. I'll be asking a few questions today. If at any point you need to repeat or repeat this question, please do not hesitate to let me know. You've been to many trampoline parks, correct?
I have, but our favorite one is Springs Park.
You used to go, sorry.
I was just saying that me and Wade love to go together.
You used to go to trampoline parks often?
I did. Me and Wade went all the time.
And one of those trampoline parks was Springs Park.
That is correct. That was our favorite park.
That's where you were on April 22nd, 2023.
Yes.
You went with your friend Wade.
Yes, we were together.
And as you said, you and Wade had been to Springs Park together many times before.
We had. It was one of our favorite things to do.
And it's true that on that day, your parents weren't there.
My parents were not there. I rode to Springs Park with some friends.
So you signed your waiver by yourself.
I did, yes.
And on that waiver, you lied about your age.
I did lie about my age, but I was only 12 at the time, and we had done it before, and nobody checked it, so I thought it was okay.
And you lied about your age so you could go into the 13 plus zones.
Yes, that was where all of Wade's friends from the JV soccer team would play.
After you and Wade had checked in, you guys went to the dodgeball zone.
We did. Well, we first went to the basketball zone. We played there for a little bit, and then we went to the dodgeball zone.
And the dodgeball zone is for children aged 13 and up.
They have different sections. There's 2 to 4, 5 to 8, 9 to 12, and then 13 to 19.
But the zone that you and Wade went into was the 13 and up zone.
Yes, that is correct.
Despite the fact that there was a zone for kids your age. There was a zone for kids your age.
There was. That was the 9 to 12 one.
And you and Wade were aware of the fact that the specific zone you were going into was.
We were, but I had a blue wristband, and nobody ever checked.
And you and Wade were both aware of the fact that you were 12 years old,
Yes, we were.
but you went in nonetheless.
That's right. Nobody checked the waiver. Nobody checked my wristband. Once again, we were only kids at the time, and we thought it was okay. We've done it before.
And despite your awareness of the rules, you stayed in the zone,
Oh, we did.
and Wade stayed in the zone.
That is correct, yes.
And it's true that when you entered the zone, the kids there were much bigger than you,
They were like college size.
and they were also older than you,
They were, yes.
but you stayed in the zone.
We did, yes.
Wade also stayed in the zone.
He did.
And when you entered the zone, the game that was going on was quite intense, wasn't it?
It was very aggressive, yes.
There were even balls being launched at people's faces.
Yes, which is against the rules, but the one watcher there didn't do anything.
So it's against the rules, but you stayed in the zone.
Yes, it's not my job to enforce the rules.
Wade also stayed in the zone,
He did, yes.
and you didn't notify the watcher.
I didn't notify a watcher. No, that was not my job.
Wade didn't notify the watcher either.
No, he was too distracted by the competitiveness of the game.
And you guys didn't just stay in the zone. You kept playing in the game.
Well, we did. Well, I got out pretty early, but we did keep playing this.
And Wade kept playing in the game.
Yes.
And it's true that when Wade played, he played near the back of the trampoline area.
That was his strategy. He liked to play more conservative. I like to go towards the front of the mats and jump behind people and try to catch the ball.
And at the back of the trampoline area, that's where the mats cover the springs.
That is correct. They kind of cover the springs throughout. There's like square sections for the whole thing.
And it's true that this area is significantly less bouncy than the rest of the trampoline.
It is less bouncy. That was the strategy that Wade used. He could run around a little bit quicker and change directions. But there was padding around basically the entire little square sections of the trampoline.
But the answer to my question is yes.
Yes.
No further questions at this time around. I have no redirect, Your Honor.
Yes, Your Honor, the plaintiff calls Dakota Stark to the stand. Permission to proceed? Could you please introduce yourself to the court?
Hi, my name is Dakota Stark.
Can you tell us a bit about your family?
Yeah, my husband Taylor is in the Air Force, and we have we had 2 boys. Jason is my youngest, and Wade was our boys.
How old was Wade in 2023?
He was 12.
Where do you live?
I live in Meadow Bay, Utopia.
What brought you to live in Meadows Bay?
That's where I grew up, actually. My husband Taylor got stationed to Germany for 2 years, and before that, we had just been in New Mexico and had just moved back to Meadows Bay. And I wanted to give the boys a hometown, so me and my husband Taylor decided that I'd stay home with the boys while he went overseas.
I want to talk about April 22nd, 2023. Can you walk us through the events of that day?
It was Wade's JV championship soccer game. He was so excited. He was only 12, but he was playing for the JV team, and there's supposed to be scouts there.
And what about that morning, before the game?
I remember searching everywhere for his, he had this lucky gray soccer shirt that he always wore before games, and I couldn't seem to find it, but I finally found it in the clean laundry.
And what was Wade's reaction when you gave it to him?
Just gave me this smile.
What about the game? How did that go?
It was intense, pretty physical. During a corner kick, Wade got his legs knocked out from under him, but fell on his shoulders and neck area.
Wait. And it happened after that.
He bounced right back up. The team doctor or the coach, they didn't take him out. He kept on playing.
What about after the game? What was the plan?
Well, Wade's coach, Coach Price, wanted to treat the team to pizza and then some celebratory time at Springs Park.
And when we got to Springs Park, what did you notice?
It was chaos. Kids running around everywhere. It didn't seem like there was enough staff watching them, and their TV screens.
Your Honor, maybe here? Your Honor, this would be a lay opinion. Your Honor, Ms. Stark saw the amount of kids and the amount of employees at Springs Park, and she could rationally, based on her perception, how the employees were handling the number of kids that were there.
Your Honor, may I respond?
Yeah, people exactly what we should.
Specifically, staff watchers to watch the kids that were there. Testified on what the precise safety should be, including Springs Park. Those witnesses are more than welcome to give their expertise. Stark is not familiar with these standards, is a member of the ITP, and therefore cannot testify.
Your Honor, maybe here? Your Honor, Ms. Stark is not testifying to the precise safety standards of trampoline park. She's just saying as to what she noticed, it seemed like there were too many kids for the employees to handle.
Sustained the objection to the question as submitted. I'll let you do it.
Yes, Your Honor. Now, without saying how many employees there were, can you tell us what you noticed about Springs Park when you got there?
It was utter chaos. There was just so many people there, and as soon as I walked in, I noticed that their TV screens were down.
What about when you went up to the front desk?
The guy at the front desk gave me a waiver.
And what did you do with that waiver?
I mean, I started reading it. I read everything before I sign, especially about my kids. The guy at the counter.
What did he say?
He looked at me right in the eye and he sighed really loudly and he said, "Look, lady, we don't have time for you to read the whole thing. There's this whole line of people behind you."
How'd that make you feel?
Rushed, pressured. I mean, there was this line of people behind me, and Wade's teammates were already heading in.
So what did you do?
I signed it.
After you signed Wade's waiver, where'd you go?
Well, the only place where parents could really watch their kids was the vending machine area. So I scooped up my toddler Jason, and that's where we went.
Now, I want you to take us to the moment when you first knew something was wrong.
Well, the trampoline park is pretty loud. There's kids laughing, music playing, people running. Then everything just stopped. I looked up at the TV screen where I'd been seeing Wade, and
What'd you see?
just this crowd of people all standing around. Nobody was saying anything. Nobody was really moving. I could see Wade on the screen. I remember my hands shaking so badly. So I scooped up Jason and we ran.
What happened next?
I remember running down the hallway and just begging to God, please don't let it be Wade. Please don't let it be my baby. But when I got to the room, I saw Robin first. I couldn't even look at me.
Can you tell us what you remember about seeing Wade?
I remember his gray long sleeve, the one he had worn that day because it was chilly. And I remember he was so still. My baby's never still. He's always moving, always active, but
When is the story? What time?
he's right. I remember someone calling 911. And I remember holding his hand and begging him to open his eyes. Begging him to open his eyes.
I'm so sorry for your loss, Mrs. Stark. Your Honor, I have no further questions at this time.
Yes, Your Honor. You may have your seat. Good evening, Ms. Stark. My name is Blair Miller, and I'm going to be asking you a few questions. If at any point you don't understand one of my questions, please let me know, and I'll be happy to answer. Your son was wearing a long sleeve shirt on the day of his accident.
Sorry. Yes, it was pretty chilly that day, and it was his favorite soccer shirt.
He was playing on a high school team.
Wade was very talented at everything he did, especially. So yes, he was playing on the high school team.
Even though he was on.
Yes, again, he's very talented. So the team did scout.
He was a great athlete. So he was playing a contact sport with children anywhere from 2 to 5 years old.
He was playing soccer with freshmen to sophomores.
And Wade was over average weight for a 12-year-old boy, yes?
He was a little over the average weight as.
Objection, Your Honor. Speculation may be heard. Your Honor, to say that Wade is over the average weight of an average 12-year-old would be to speculate. This witness has no knowledge of what the average 12-year-old's weight would be.
Your Honor, may I respond? This witness did have a 12-year-old boy who she was obviously very familiar with, and she would know his statistics according to the average. In addition, if this witness is unsure, this is a cross-examination, so she can say what she wants.
Your Honor, may be heard. Your Honor, my witness has a 12-year-old boy who she claims, or who my opposing counsel is trying to say is over the average weight of a 12-year-old boy. So, Your Honor, she would not have knowledge of the average weight of 12-year-old boys.
I'm gonna overrule the objection.
Yes, Your Honor.
Ms. Stark, Wade was over the average weight for a 12-year-old boy.
Yes, he was a little tall for his age. He gets it from his dad, but yes, he was a little over the average weight.
You said he was tall for his age. He was over average height as well.
From what the doctors have told me, yes.
8.5 inches taller than average.
I believe that's what his pediatrician told me.
And you had taken Wade to other trampoline parks in the past, yes?
Yes, it is true.
You also allowed him to go without you in the past?
I believe he's gone with his friends a couple of times to some trampoline parks, but their parents were with him.
And you'd agree with me that there is a certain amount of risk inherently associated with trampoline parks, correct?
Objection, Your Honor, under Rule 702, may I be heard? Your Honor, the risk of a trampoline park would be an expert opinion based on scientific, technical, or otherwise specialized knowledge. And Your Honor, my witness has not been tendered in any sort of field relating to trampoline parks.
Your Honor, may I respond? I'm only asking for the witness's prior knowledge based on the fact that she had been to trampoline parks before and therefore seen other waivers. But again, this is a cross-examination, so if the witness is not sure, she does this.
Yes, Your Honor.
Ms. Stark, you'd agree with me that there's a certain amount of risk inherently associated with trampoline parks, correct?
I do believe so, yes.
And continuing on, you stated that there were some things about Springs Park that concerned you on your direct about the safety upon entry.
Yes, that is true. There are many things that just were not right at that park.
But you are not a member of the International Association of Trampoline Parks?
No, ma'am.
And you have no formal education related to risk prevention?
No.
And you weren't present on the morning of April 22nd at Springs Park to witness the daily safety checks performed by Springs Park employees?
No, I'm not an employee of Springs Park.
So you cannot testify to the sufficiency of these checks?
No, as I'm not an expert. My contentions are really just my observations and me comparing to other parks I've been to, and it just did not seem right at that park.
You're not familiar with the International Association of Trampoline Parks standards of sufficient risk prevention?
No, as I'm not a member.
So you cannot testify to whether or not Springs Park is meeting these standards because you're not familiar with them?
Again, I'm not a member, so no, I can't.
And prior to your son's accident, you didn't enter any areas of Springs Park other than the front entrance and the bending and leaving area, correct?
Yes, that is true, but I did pass by the toddler area where I did see high school age kids bouncing with toddlers.
But the answer to my question about those areas is correct.
Yes, ma'am.
So you cannot testify to whether or not there was safety signage posted around the inside of the park denoting rules, risks, and warnings to the actual participants?
No, I cannot testify to that, but I didn't see it.
Thank you, Your Honor. No further questions at this time.
And no redirect, Your Honor.
Yes, Your Honor, the plaintiff calls Dr. Mills Barton to the stand. And Your Honor, before I proceed, may I ask for a time check?
You have 6 minutes and 54 seconds remaining.
Good evening. Could you please introduce yourself to the court?
Yes. Hello there. My name is Mills Barton.
And could you tell us a little bit about yourself?
Of course. So I currently serve as the chair of emergency medicine at Scripps Mercy Hospital, which is located in San Diego.
And can you walk us through your training and background?
Yes, sir. So I started at Northwestern University, my undergraduate degree, and then I went to Johns Hopkins for medical school. And then after I did that, I went to the University of Maryland Medical Center, and I completed the shock trauma unit, where I eventually became chief resident.
So, doctor, what type of medicine do you practice?
Well, I specifically practice sports medicine. While I am an orthopedic surgeon more broadly, My specialty is in sports medicine.
All right, and what brought you this case specifically?
Well, a little while ago, I wrote this peer-reviewed article, and not to brag, but it is one of the foremost articles that specifically talks about Trump theme parks.
All right, and what facts and data did you rely on in your investigation?
Well, I interviewed a couple different people. I also was able to tour Springs Park's facilities, and I was also able to rely upon the autopsy report, Exhibit 5.
And what principles and methods did you apply?
I used the standard principles and methods in my field of expertise.
Did you reliably apply the principles and methods to the facts and data of this case?
I did, yes, sir.
Your Honor, at this time I tender Dr. Mills Barton as an expert in the field of sports injuries and medicine.
No objections, Your Honor.
All right, let's talk about your findings in today's case. Permission to approach with Exhibit 5. Let the record reflect that I'm getting a copy of those accounts. Would Your Honor like a copy? All right, permission to approach the stand. All right, I'm showing you Exhibit 5. Do you recognize that?
Yes, sir. This is the autopsy report that I was actually just talking about.
And is it a fair and accurate copy?
It is, yes.
Is this the same type of information that other experts in your field reasonably rely on?
Yes, sir.
Your Honor, at this time I offer Exhibit 5.
Objection, hearsay.
May I be heard as to that, Your Honor? Your Honor, this would be admissible pursuant to Rule 703. Your Honor, Rule 703 states that experts may rely on otherwise inadmissible information if it's the same type reasonably relied on by other experts in the field. Your Honor, we heard from the witness that this is in fact the information that she relied on in her conclusions, and it's the same type reasonably relied on by other experts in the field. Your Honor, 703 also states that this information can be disclosed to the jury if the probative value substantially outweighs the risk of unfair prejudice. Your Honor, this evidence is highly probative as it illustrates the cause of Wade Stark's death, which is a key factor in today's case. And Your Honor, there's no unfair prejudice to this evidence.
I stand by my objection, Your Honor.
I'll overrule the objection.
Excuse me, permission to publish to the jury?
Any objection to the publication of the jury?
No, Your Honor.
All right, Doctor, let's continue to talk about that. Could you show the jury where Wade Stark's injury occurred?
I would love to, but it would be a lot easier if I had someone to kind of demonstrate it on. I hate to ask, but would you be willing to be my guinea pig, Mr. Duckett?
Your Honor, may the witness step down?
No, Your Honor.
Right, if you could just stand right about here, that'd be great. Thank you. All right, so the critical area that I want to kind of talk about is this area right here at the base of the skull. So if you kind of look at where the head meets the neck, there are two very important vertebrae. So the first one, C1, is right about here, and the second one, C2, is just slightly below that one. It's right about here.
And can you explain how these vertebrae normally work together?
Of course. So C1, remember, that is the first one on top. It's sort of like a ring that your skull kind of sits on. So when you nod your head, if you could nod your head, that is the C1 vertebrae moving. And if you turn your head to the side, thank you. That is.
Yes, Your Honor. May I be heard as to that? Your Honor, understanding the vertebrae C1 and C2 is very important to today's case. As if I may proffer, Your Honor, the witness is going on to testify how when these vertebrae fractured, it caused the death of Wade Stark.
Your Honor, may be heard. Under Rule 402, we are here today to discuss negligence and injury caused to the plaintiff, and I don't see how nodding your head and how your vertebrae contributes to that is relevant to the injury.
Your Honor, may I be heard as to that? Would you like to, did you have anything more to add to that answer?
Just a little bit. So if you turn your head to the side, That is both the C1 and the C2 moving together.
So what happened to these vertebrae when Wade Stark fell?
Well, when Mr. Stark fell on the mats, that force, it caused the C1 and the C2 vertebrae to kind of break apart, and that broken bone, that broken vertebrae, it then kind of shifted slightly and eventually severed Mr. Stark's spinal cord.
Thank you, Doctor. You can return to your seat. Now, we've heard some about a prior fall at a soccer game. In your professional opinion, could that have had anything to do with the injury?
That is a very good question, and the answer to that is no. The autopsy report was very, very clear. There is no other medical cause other than the fall at Springs Park.
All right, now I'd like to discuss your evaluation of Springs Park. Did you perform an inspection?
Yes, sir. I went to Springs Park and I specifically looked at their 13 and up dodgeball area. And while I was at Springs Park, I also spoke to Miss Wilson over there.
And what did this investigation reveal?
Well, like I said, I looked at the dodgeball zone and I looked at the mats, and I learned that the mats hadn't been replaced in 8 years.
And why was that significant?
Well, the mats are the only thing that is protecting
Objection,
the guests.
improper opinion.
Your Honor may be yours to that. Your Honor, this witness is accepted as an expert in sports injuries and medicine. This falls well within the scope of her expertise, as the entire purpose of these pads that she's discussing is to prevent a sports injury. She is therefore qualified to testify as to whether or not these pads would be able to prevent a sports injury.
Your Honor, may be heard.
I'm going to sustain the objection. I'll certainly allow you to ask more foundational questions.
All right, so doctor, in your professional opinion, were these pads sufficient to prevent a sports injury from occurring?
No, sir. You see, these cushions, these mats, were unable to cushion Mr. Stark's fall, and those mats are really the only thing that is protecting against.
Objection, improper opinion.
Yes, Your Honor, I'm asking the witness about her opinion as to whether these mats can prevent a sports injury from occurring. Again, her field of expertise is sports injuries and medicine, so this is well within that field.
Overall objection. Proceed.
All right, were you finished with your answer?
Not quite. So basically, I was saying that these mats were unable to effectively cushion Mr. Stark's fall, and as a result, his C1 and C2 vertebrae unfortunately severed, and eventually severed his spinal cord.
Thank you, Dr. Barton. Your Honor, at this time, I have no further questions.
May I proceed? Good evening, Dr. Barton. My name is Iman Nazir, and I'll be asking you a few questions today. If at any point you don't understand, please let me know, and I'll be happy to rephrase. Now, you treat traumatic sports injuries, right?
Yes, ma'am, that is my job. I am a surgeon, so I treat all sorts of cases involving sports injuries.
You don't have an engineering background.
No, ma'am, I am a surgeon. That is what I do.
You're not a certified safety consultant.
No, ma'am.
You're also not a member of the International Association of Trampoline Parks.
No, ma'am, I am not.
Despite this, you were hired by the plaintiff to investigate their son's death at a trampoline park.
Yes, ma'am, the Stark family did hire me after the unfortunate accident at Springs Park.
Right, and you only testify in cases when you're paid by an interested party?
I wouldn't say that necessarily. I testify in cases when people hire me to testify on behalf of them.
But you are being paid for your testimony today, correct?
Yes, ma'am, it is my job. I'm putting work and hours into this, so of course I'm being paid.
Now, moving on to the article you discussed during direct. In the article, your only recommendation was that parks employ EMT, right?
Yes, ma'am, that was my recommendation.
But even if Springs Park had employed an EMT, Wade would still have suffered the same injury.
That is true, but having an EMT, on site, is very important, because if something ever happens, they can hopefully help and mitigate any risks.
So even if your safety recommendation had been followed, Wade would still have died?
It's a possibility, yes.
And in your article, you never discussed the matting at trampoline parks, did you?
And
in your article about trampoline parks.
Yes, ma'am, I did not mention that.
But during your investigation, you focused on the matting.
Yes, ma'am, as it was an important part of what happened in today's case.
And the only experience you have with trampoline parks did come from the article, right?
Yes, ma'am, I am a professional in my field, and I have researched trampoline parks extensively and am very familiar in the specific field.
But you claim that the matting and the springs underneath is what caused Wade's death?
Yes, ma'am. Mr. Stark's neck, he hit a metal spring or metal frame, and that is ultimately what caused his death.
But you never looked at the springs or metal frame, did you?
No, ma'am. I went to Springs Park, but they would not allow me to go under the crawl space. I asked, and they said no.
So you made this conclusion without even being able to see what you claim caused it?
Well, ma'am, like I said, they wouldn't allow me to go under there. But based on my experience in this field, that is what caused Wade Stark's death.
But you weren't there on the day of the incident?
No, ma'am, I was not.
There was no surveillance footage of the day?
Not to my knowledge, no.
So you can't testify to how the staff was working or how the rules were enforced on the day of the incident?
I was not there, so I cannot testify as to that.
Now, moving on to the nature of the injury, there are over 100,000 trampoline park injuries reported to the ER every year in the U.S., right?
Objection, Your Honor, relevance and 403, may I be heard? Your Honor, first of all, subject to Rule 401. The amount of other injuries that occur in trampoline parks has no tendency to make a fact of consequence more or less probable when determining whether or not Springs Park was the cause of Wade Stark's injury. Secondly, Your Honor, under Rule 403, I would contend that this evidence is substantially more prejudicial than probative, as the vast amount of other injuries might diminish, in their mind, the impact of Wade Stark's injury. In any case, this has no tendency to prove whether or not Springs Park is liable in today's case.
Your Honor, may I respond? Under Rule 402, one of the elements we have to prove today is negligence, and one of the tests of negligence is a breach of duty. If I may proffer, I'm offering this evidence to show that there are lots of trampoline parks, and it is inherently a dangerous place to be in, and thus negligence cannot fall upon Springs Park.
Your Honor, may I concur as to that? Your Honor, the amount of injuries that happens at other trampoline parks does not diminish the responsibility of Springs Park to provide a safe environment for their guests. This evidence does nothing to advance a theory of negligence.
Do you want me to repeat my question?
Yes, please, that'd be great.
There are over 100,000 trampoline park injuries reported to the ER each year in the U.S.
Yes, ma'am.
And you believe that the actual injury record is probably tenfold?
Yes, ma'am, I do believe that. I feel like trampoline parks, if they don't have certain rules and regulations in place, they can be dangerous.
So you believe that trampoline parks are an inherently dangerous place to be?
Like I said, they can be if they, the staff aren't following rules, if they don't have regulations or specific rules in place to prevent their guests from getting hurt.
You also weren't contacted by the Stark family until late May of 2023?
Yes, ma'am, that is when they contacted me.
But the incident happened in April?
I believe so, yes.
Thank you. No further questions, Your Honor.
Your Honor, I have no redirect, and at this time, the plaintiff rests.
Your Honor, the defense calls Jordan Banner to the stand. May I proceed? Please introduce yourself to the court.
My name is Jordan Banner.
Where do you live?
I am currently a resident of Meadow Bay, Utopia.
Where do you work, Ms. Banner?
Currently, I am the facility manager at the West Maple Drive location of Springs Park.
And how long have you worked at Springs Park?
I've worked at Springs Park since I was 16 years old, which makes it about 9 years now.
What positions have you done in that time?
I've done every position available to me before my current one.
And what are those positions?
This includes our front of the house staff, this includes our watchers, our extra position of roamers, and of course, my job currently.
What are the responsibilities of the front of house staff?
The front of house staff are going to be the first person that a customer sees when they come into our facility. So they're in charge of making sure that everybody kind of knows the rules and also in charge of making sure that every guest either signs our liability waiver or knows that they cannot be jumping on our trampolines.
What are the responsibilities of the watchers?
The names here are kind of on the nose. So the watchers watch. In each zone, there is one person dedicated to make sure that there is the correct number of people in each room because we do need to abide by both fire safety codes and also IATP standards. They are there to make sure that nobody is breaking the rules and also making sure that people are in the safe and correct zone. The biggest problem with people in the wrong zones is somebody of a vastly different height or weight or athletic ability. So we have this wristband system that we generally break up into different age groups that kind of have a noticeably different kind of growth spurt. So they're broken up so it's easier for our watchers to see.
You also mentioned roamers. What are their responsibilities?
The names here, as I said, are kind of on the nose. We're not very creative, so the watchers watch, the roamers roam. They do everything that the watchers do, except instead of staying in one room, they wander around the entire facility.
And finally, what are your responsibilities as facility manager?
As the facility manager, I am there to make decisions on the day-to-day. Sydney can't be in every single park at once, so if something may occur, I'm the one who has to respond to it. I just make sure that everything is smoothed over and everything is successful.
Moving on, what types of trainings do your employees receive?
Our employees are trained to the utmost ability. We receive 40 hours of training before we even begin. This includes knowing our rules. This includes our first aid training. This includes our emergency protocol that we call CARE, and also the general know-how. Of course, we receive an additional 20 hours of training annually, one-on-one with Sydney to act as a refresher to make sure that every single one of our staff members is acting as they should be.
How are your employees trained to react if something goes wrong?
There are, of course, things that we can kind of predict might go wrong at some point, so we do everything we can to mitigate any problems, and we have procedures in place. If something that we don't expect goes wrong, it's up to my discretion as the facility manager to decide on whether that's something that we can solve ourselves, or if I need to contact Sydney for a solution.
And speaking of things that can go wrong without you knowing, what do you do when an employee calls out sick?
This is one of the things that we can predict might go wrong. People are human. Sometimes people get sick. We staff additional members than what we need. We staff 18 people, and the IATP standards requires 15 for our park. So missing 1 to 2 people is absolutely no big deal. We are staffed where we need to be. If we're missing more than that, then I will contact Sydney, and she will send over additional staff members.
Moving on, on the morning of April 22nd of 2023, what things did you do at the facility?
That morning started basically as usual. Sydney and I were the first people in the park. So we did our daily safety checklist to make sure that all of our equipment was functioning properly, and it was. Sydney left to go visit one of the other parks, and the rest of our staff filed in. A little bit before we opened, I noticed that we were 2 staff members down, but I just reallocated people because we were functioning properly.
What, if anything else, abnormal happened that day?
A little bit before noon, the tablets and screens in our front of the house went down. This is another thing that we can kind of predict might go wrong. Technology is notoriously unreliable sometimes. So we were originally a paper run facility. So I would go and grab the paper waivers out of the back, and then our TVs just displayed our safety signage, which we have numerous of in the front and around the park.
You mentioned earlier that you were missing a few people. After you had dealt with these problems, what additional roles did you fulfill to help accommodate this?
I acted as the roamer for that day. The roamer is an extra position, as I kind of mentioned, so I was just wandering around the facility. When we had that little snafu with the technology, I went up front to help smooth things over and get things running as they should be, but once everything up there died down, I returned to walking around as a roamer.
What was the facility like while you were roaming?
The facility was exactly as it always is until it wasn't.
What happened?
Part of the facility went quiet, which of course is a really big red flag in our facility because we are mainly geared towards children and teens, so screams of like excitement and joy is the regular. So having a place go quiet is not good. And then of course I heard a cry for help.
How did you react?
I immediately ran towards it. I was obviously on guard when I heard it go quiet, but the cry for help snapped me into action.
And what did you find when you got there?
When I got there, I saw a crowd of people in the corner. I got closer, and that was when I saw Wade.
How did you respond to seeing him?
I honestly had to take just a second to kind of rationalize what I was seeing. Nothing like this had ever happened in Springs Park before. Luckily, in that moment of rationalization, I remembered the emergency protocol and I immediately launched into that. I cleared the area to make sure that we avoided exacerbating the injury further. I assessed what was going on. I went down to take Wade's pulse, and this was the first time that I noticed that he was not in the correct room. I pulled up his shirt and saw he was wearing a long wristband. His pulse was incredibly faint, so I knew that this was out of my scope of first aid ability, so I called EMTs. I waited with Wade until they arrived, and after he had been loaded in the ambulance and taken to the hospital, I shut down our facility because we needed to evaluate what had happened. We did a check through of the facility, and I had called Sydney, and she came, and we did an additional check of the facility.
And what did you find when you were reevaluating the facility?
I found that everything in the facility had been exactly as it was that morning, and that morning it had been in perfect operational order.
Objection, Your Honor, improper opinion under Rule 702 may I be heard. Your Honor, for this witness to testify that equipment was in perfect operational order, Your Honor, they would have to give a testimony based on scientific, technical, or otherwise specialized knowledge. And under case law Frankfurt Shrimp Shack v. Broughton on page 21 of the case packet, an expert must be tendered in a specific field to provide an opinion. There has been no foundation laid for this witness to provide an expert opinion. So this would go beyond her scope of a lay opinion, and it would be improper opinion under Rule 702.
Your Honor, come in. This is admissible under Rule 701A, as the witness has already testified that they went through and evaluated all aspects of the facility, and they are now just describing what they found when they did that.
Yes, Your Honor.
What other things do you do to keep your facility working properly?
We just kind of, the biggest thing, of course, is our training. We make sure that everybody's adequately trained. And just if anything goes wrong, we've got these protocols in place because we want to mitigate anything that we can before it occurs.
Thank you. No further questions at this time.
Yes, Your Honor, permission to proceed. Good evening, Ms. Banner. Now, you said something on direct examination, and I wrote it down. You said that IATP requires that you have 15 staff members working at all times, and that you had 18 staff members at Springs Park?
We had 16 that day.
Is your testimony that you had 16 staff members working at Springs Park on April 22nd?
Yes.
Your Honor, permission to approach the witness with a copy of her affidavit for purposes of impeachment? Let the record reflect I'm handing a copy to opposing counsel. Thank you. Would Your Honor like a copy? Permission to approach the witness. All right, now, Ms. Banner, this is your affidavit.
Yes.
That's your name at the top. I'm going to need to get verbal yes or no.
Yes.
And that's your signature at the bottom, right?
Yes, it is.
And so looking throughout here, you talk about April 22nd. Talk about April 22nd over here, but nowhere in here do you include the fact that you had 16 staff members working there that day, correct?
Objection, improper impeachment.
Explain further.
Your Honor, the opposing counsel does not like the proper foundation of what an affidavit implies, or that the witness had a proper understanding of what the affidavit implies.
No, overrule the objection.
Yes, Your Honor. All right, now, Ms. Banner, before coming to court today, you were told to include all relevant information in this affidavit.
Yes, I was.
So you'd agree that nowhere in this affidavit do you say that there were 16 staff members working on April 22nd?
No, it does not say that.
All right, so you're supposed to have 14 staff members working at all times, right?
We are supposed to have 14 watchers at all times, and then an additional person acting as the front office staff member.
All right, but on April 22nd, you were 2 staff members short.
Yes, we were.
Now, when you saw that, you had a choice, didn't you?
Yes,
You could have turned people away.
I could have.
That's right, but you kept letting customers in.
We have the fire safety codes, obviously, so the number of people coming into our park did not affect the number of people in the room, because if there were too many people in a room, we of course would turn people away there.
All right, well, I want to address why you made that decision. Now, the profitability of the park, it means a great deal to you, doesn't it?
Objection, relevance.
May I be heard, Your Honor? Your Honor, if I may proffer, this line of questioning is going to show a potential bias. And under case law Davidson v. Smith and page 21 of the case packet, the finder of fact must always consider a witness's interest in the outcome of his case.
I stand by my objection, Your Honor.
Yes, Your Honor. All right, so Ms. Banner, the profitability of Springs Park, it means a great deal to you, doesn't it?
I mean, it's my job, yes.
All right, but you want to be more than just a manager, don't you?
I mean, the next step would obviously be doing something else, but
That's right, Ms. Banner, if Springs Park were to open a 4th location, you want to be a part.
I would apply for the job, of course. It's the next step in my career, but I would have to go through the job application like every other person. There are other managers for other Springs Park locations.
All right, well, you'd agree that that could only happen if the business stayed good, right?
I mean, that is an element of it, yes.
So instead of closing the park, you kept the doors open.
Yes, because we were functioning with the amount of people that IATP standards require.
You kept taking customers in.
Yes.
You kept taking in money.
Yes.
All right, now I want to address a few more decisions that you made. Now, you heard from Robin Hill that he was not allowed to read his own waiver.
No, I did not hear that.
I'm sorry, you heard from Robin Hill that he was allowed to sign his own waiver, right?
I don't think he was allowed to. We have an honor system here at Springs Park. We trust that a child will be with some form of adult, and if a child signs their waiver, that is not our fault.
Well, Ms. Banner, you heard that he did sign his own waiver.
I know that Robin Hill came in with a large group of children and adults, so we trusted that the adults would take responsibility for the children in their group and sign for him.
Okay, so you can't say for certain whether or not your staff did allow him to sign his own waiver.
I know that now they did, but I didn't know that at the time.
All right, so you also heard from Robin Hill that the staff members were not checking wristbands.
Our staff members were absolutely checking wristbands. If somebody is visibly out of place in a room, they will, of course, look at the wristband that the child is wearing to verify the age and then remove them from the room.
But Ms. Banner, you heard from Robin Hill today that that the staff members in the 13 and up room were not checking the wristbands. I'm going to need a yes or a no.
I heard that Robin thinks that our staff members were not checking wristbands. We obviously need to have them looking out for a ton of different things. So I don't know if Robin Hill truly knows whether or not my staff glanced at his wristband.
Right, now, Ms. Banner, you can't say for certain whether or not your staff member did check Wade Stark's wristband.
I assume that they did because that is their job.
But Ms. Banner, you cannot say for certain.
No,
Objection asked and answered.
May I be heard, Your Honor? Yes, Your Honor. All right, so Ms. Banner, you cannot say for certain, correct?
I cannot say for certain, but I have absolute trust in my employees.
All right, so we've talked about some things that you can't say for certain. But let's talk about one thing that you do remember. You do remember going into that 13 and up room before Wade Stark's accident?
Yes, I had walked around the entire facility twice before the accident occurred.
You do remember telling those kids to play hard.
I mean, I always encourage kids to have fun. In that room, it does come in the form of athletic ability.
But Ms. Banner, you knew that encouraging harder play, that could be more dangerous.
It could be, but I trust that our staff members are keeping an eye out for what they should be. So any encouragement of athletic play is just encouragement of having fun.
But Ms. Banner, you knew that kids could get hurt.
I didn't believe that kids could get hurt.
But you would agree that rougher play, that is more likely for kids to get hurt.
It could be, yes.
All right, thank you, Ms. Banner. Your Honor, I have no further questions.
Yes, Your Honor. May I proceed? How many zones are there at the West Maple facility?
There are 14 zones.
And how many people do you have in each zone?
We need one person in each zone.
What are the IATP standards for staff in these zones?
The IATP standards say that you need one person per zone.
And what were the implications of having 2 people call in sick that day?
It meant that we needed to reallocate the watchers, the roamers that we additionally have, to watchers to make sure that every room has one watcher.
And what effect did that have on your following of the IATP standards?
We were still following them perfectly.
Additionally, what are the IATP standards for the amount of people you can have in the facility?
We required that only 6 people are on each trampoline.
And how were these requirements followed?
Our watchers are trained to count the number of people per room. So,
Objection, Your Honor. Scope, may I be heard? Your Honor, I did not ask this witness anything about the amount of people allowed in a room on my cross-examination. So this would go outside of the scope of my cross-examination under Rule 611.
Your Honor, if I may. Opposing counsel asked the witness about why they kept letting people into the facility. And this directly goes to that.
Yes, Your Honor.
You were talking about how you follow the IATP standards for this?
yes, our staff members are trained to count the number of people in each room for these IATP standards and fire safety codes. So 6 people are allowed on each trampoline in a zone.
And you followed these?
Yes, we did.
Thank you. No further questions of this time, Your Honor.
I have no recross, Your Honor.
Your Honor, the defense calls Bailey Parker to the stand. May I inquire as to a time check?
You have used 9 minutes and 41 seconds.
May I proceed? Would you please state your name for the record?
Good evening. My name is Bailey Parker.
Where are you currently employed?
Currently, I work as an independent safety consultant for my own company, Safety Defense and Risk Management, and I've owned and operated that business for the past 10 years now.
What's your previous work history?
So previously, I worked as an insurance agent for an insurance company, Sweetgrass, and I worked there for around 25 years, and I really loved what I was doing, getting to help companies recoup after loss. But after doing that for so long, I wanted to do more. I wanted to get ahead of that and help companies prevent loss before it happened. So that's how I got into my business.
Could you describe your educational background?
Yes, so I started my education at the University of Montana, and there I got my degree in mechanical engineering. And after that, I wanted to receive some sort of further education in the area of safety consulting, but there are no colleges that offer formal degrees for that area, so I instead supplemented that with various certifications.
What areas are you certified in?
I have 7 certifications in the realm of safety consulting. Some of my more significant ones include a master's certification from the National Casualty and Risk Assessment Center, a gold certification from the Utopia Commission on Risk Assessment, and I'm also a member of the International Association of Trampoline Parks.
Could you describe your daily work as a safety consultant?
Of course. So as a safety consultant, basically what I do is help companies assess potential areas of risk and just general unsafe practices in their businesses and what they can do to make things run as smoothly as possible both for them and their customers.
Have you worked with trampoline parks in the past?
Oh, plenty. I've worked with trampoline parks as an insurance agent, again, helping them recoup the loss after the fact. And more recently, I've worked with trampoline parks, helping them revise or write their waivers for their facilities. And I've also done standard risk assessments for trampoline park facilities. Additionally, I am a member of the IATP, as I said, and I've gone to and spoken at conferences for them as well.
How do you regularly conduct your analysis?
It really depends on the business I'm helping and what industry they're in. I base all of my analysis off of the industry standards and, of course, my own experience in the insurance industry. And I use those standards to measure what they are meeting up to and what they might need to improve on to really just have a safe company.
Are these methods reasonably relied upon in your field?
Yes, they are.
Did you apply them in today's case?
I did.
And did you have sufficient facts and data to support your conclusions in today's case?
Yes, I did.
Your Honor, at this time, I move to enter Bailey Parker as an expert in safety and risk assessment and management.
I have no objections to that field, Your Honor.
How did you get involved in today's case?
I was contacted on the evening of April 22nd by Sydney Wilson to come down and do a risk evaluation for the West Maple Springs Park facility.
Was this the first time you had seen this facility?
It was not. I've done informal evaluations of all 3 Springs Park locations in the past.
Could you briefly describe what you observed at these informal assessments?
Of course. So there are 4 main observations I've made during all of my tours of all 3 facilities. First and foremost being the safety signage at these facilities is posted liberally around, both in the entrance area, on screens, and on paper posters on the walls, and within the actual rooms of this facility, all across the walls, things like that. Second would be the viewing areas for parents to watch their children while they're playing at the parks. Third would be the age groups that all 3 facilities are divided up into with the wristband system, which is a IATP recommendation that this park follows to the highest degree. And finally, it would be the daily safety checks that the staff performs before the opening and closing of the park to ensure that everything is running smoothly.
In your formal assessment of the West Maple facility for today's case, what did you observe then?
I arrived at the West Maple facility the Monday following the accident, as I had to drive down from Montana. When I arrived, I walked through the facility, same as I had prior in my previous investigations. I, of course, did pay a little bit more attention to the dodgeball zone this time because that is where the accident that we are discussing here today occurred. I examined all the equipment in that room, including the equipment underneath the mats of the trampolines, which would be the springs, the metal frame, things like that. And everything in that room was up to code. After I was given the daily safety checklist for April 22nd, and everything on there had been clearly double checked.
And after all of your analysis, what conclusion did you draw in today's case?
I was able to come to the conclusion that Springs Park had done everything they could to make the facility run as smoothly and safely as possible on April 22nd. And I've seen this time and time again across countless different industries, countless different businesses, where they will do absolutely everything in their power to mitigate risk within their day-to-day workflow. But some things just cannot be fully eradicated. But Springs Park did the absolute best they could to run a safe and functional facility.
Thank you, Your Honor. No further questions at this time.
Yes, Your Honor, permission to proceed? Now, Mr. Parker, would you say it's important for an expert to look at all the evidence objectively?
Yes, all the evidence that is relevant to their testimony and what they're testifying on.
To avoid bias?
Yes.
To be as neutral as possible?
Yes, that would be the definition of bias.
This person right here in the pearls, this is Sydney Wilson.
Yes, it is.
And you actually have a pre-existing relationship with her, don't you?
I met Sydney Wilson at one of the IATP conferences I was attending, and we formed a functional working relationship, yes.
Well, you've known her for years.
Yes, I met her at an IATP conference a few years prior.
You had met at a conference.
Yes, we did.
You had dinner together.
Yes, the conference had ran a bit late, and again, I enjoyed networking with my clients. I wanted to make connections in all industries, including trampoline parks. So yes, we went out to get a meal and discussed further our business practices.
And you hit it off pretty well.
Yes, I'd say we had a great working relationship.
You hit it off so well, in fact, that you don't refer to her as Sydney or Miss Wilson. You refer to her as
Objection
Sid.
relevance.
Your Honor, may be heard? Your Honor, according to...
I didn't hear the whole question. You refer to her as?
You don't refer to her as Miss Wilson or Sydney. You refer to her as Sid, a nickname. And Your Honor, according to Davidson versus Smith on page 21 of the case packet, a witness's credibility is always at issue, and it is the finder of fact's job to bring up the witness's intentions with the case.
Your Honor, may I respond? I understand that there is relevance in establishing whether or not there is bias to certain extra witnesses, but we've well established whether or not that occurs here. There's no need to address what Ms. Parker and Sydney refer to each other as. That's far outside of a bias relevance.
Your Honor, may be heard? Yes, Your Honor. Now, you don't refer to Sydney as Miss Wilson or Sydney. You refer to her as Sid.
While that might be true, I find no relevance about what I might refer to Sydney as in the scope of this case. I believe that's not what we're here for today.
But you don't only have a personal relationship with her, she's also offered you a job.
Well, I am an independent safety consultant. My business relies on the networking relationships I've formed with my clients, and yes, that is true.
As a consultant?
Yes.
At her new Springs Parks location?
We have discussed the possibility of her opening a fourth Springs Park location and me being hired as the safety consultant to perform an examination of that facility like I've done all the others. Yes.
And like you said, it's important for your business to have a relationship with your clients, so you actually have a financial stake in the outcome of this case.
I have no significant financial stake in the outcome of this case. It would just be another client, but I suppose you could say that.
It's pretty hard to be neutral about someone you're friendly with.
I have a professional relationship with Sydney Wilson, and once again, I do not see the relevance of what we're here to discuss.
Pretty hard to avoid bias when there's money on the line.
There is no significant amount of money that could get me to give a biased testimony in a case as important as this one, or any case for that matter.
Now, I want to talk a little bit about your investigation after Wade Stark's death. Now, you did a thorough investigation of Springs Park.
Yes, I did.
And you wrote a report on that investigation.
I have.
Your Honor, permission to approach with the witness's affidavit for purposes of impeachment? Let the record reflect. I'm showing a copy to the counsel. This is your report?
Yes.
And you wrote this report?
Yes, I did.
So you know this report pretty well?
Yes, I did.
Now I'm going to be referring to lines 82 through 93.
Objection, improper impeachment.
Okay, just saying something about 2 lines that's quite considered. Coming from.
I'm going to be referring to lines 82 through 90. This is where you talk about your inspection after. And you're aware that allegations is that the safety rules weren't properly communicated.
Yes, I'm aware that that's one of the things we brought to the test today.
And you heard today that the screens in the front lobby were down on April 22nd, 2023?
Yes, that's true.
And now, could you show me where you mentioned that in your investigation? In these lines.
I did not particularly mention that within those lines.
And another thing that the defense or the plaintiff claims is that Springs Parks was not properly enforcing their safety rules. Is that correct?
It's another claim.
Objection, improper impeachment, may I be heard? If opposing counsel is trying to impeach this witness by omission, then she must be able to fully read through her affidavit or look through her affidavit to show the jury where she may or may not have mentioned things. If it's by contradiction, then this impeachment is obviously proper because nothing specific has been stated.
Your Honor, maybe here? Your Honor, since we have time restraints in Utopia for crosses, we are allowed to point out specific line numbers as to speed up the duration of the cross.
Your Honor,
The objection, which has some merit, is impeachment by omission as opposed to impeachment by something said. Would you like to respond to whether you think it's properly pre-impeachment for something that is not said?
Yes, Your Honor. Lines 82 through 93 is where the witness discusses her investigation of Springs Parks. If she knows another spot where this is, she can tell me, but if she does not, it is for the sake of time to keep it confined to these lines.
Why don't you just ask her if she expressed an opinion about this thing? If she says something that's inconsistent, then you can proceed with the affidavit. Why don't you ask her that question? Those questions.
Yes, Your Honor.
So basically sustaining the objection on that.
Yes, Your Honor. Now, you heard testimony from Robin Hill that Jordan Banner was encouraging kids to play harder. Is that correct?
Yes, I heard Robin Hill testify.
But you didn't include that in your investigation, did you?
My investigation was not how the park was run on April 22nd. My investigation was the facility and how the equipment was maintained and everything within the facility that I examined, not what you are trying to suggest.
So let me get this straight. Whether or not the manager was encouraging kids to play harder is not a safety concern?
I did not say that it was not a safety concern. I said that's not what I'm here testifying to today.
Thank you. Your Honor, I have no further questions.
briefly, Your Honor. Ms. Barker, we've established that you're being paid today for certain aspects. Could you remind us what it is that you're being paid for?
Yes, I'm being paid here today for my time spent in court. I am also being paid for the examination I conducted of the Springs Park facility.
Does your testimony today affect at all what amount or if you are being paid or not?
No, has no impact on it.
Thank you, Your Honor. No further questions at this time.
No recross, Your Honor.
Your Honor, the defense calls Sydney Wilson to the stand. May I proceed? Could you please introduce yourself to the court?
My name is Sydney Wilson.
Where do you work?
I act as both the owner and operator of Springs Park.
Can you tell us a little bit about how you came to form Springs Park?
Of course. About 10 years ago, I was working at a textile company as an environmental safety officer when I noticed that a Walmart nearby shut down. And with my values in exercise and entertainment for children, including my own, I decided to use my resources in opening a trampoline park myself.
And did you do any kind of research before opening the park?
Yes, I did a ton of research in regards to safety. As I said, I have children myself, and keeping them safe is very important to me. And I wanted to apply that to my guests as well, so I spent about a year doing research. First, I looked into any laws, but unfortunately in the US, there aren't any official laws regarding trampoline parks. But then I looked towards the IATP, became a member myself, and implemented all of their regulations.
So what kind of safety measures did you specifically implement?
I purchased the equipment that they recommended, even going beyond their recommended thickness for mats and things like that. And then I also created a 4-inch overlay on the matting to exceed their recommendations. And for safety rules, I created rules that would protect both the guests and our equipment. So we prohibit things like throwing dodgeballs at each other or bumping into each other on purpose to prevent injury. And then for my equipment, I prohibit guests from jumping directly on the mats so as to prevent further compression.
Do you have any daily safety procedures you follow?
Yes, on a daily basis, all our facility managers conduct safety inspections of our parks.
And do you have any kind of emergency protocols when injuries happen?
Yes, when injuries happen, we like to use the acronym CARE. So our staff will clear the area, assess the situation, respond to it, and then once everything has been handled, evaluate what has happened.
How is your trust aimed? How is your staff trained?
New staff members receive 40 hours of shadowing, getting to know the protocols at the park, and then each individual staff member receives 20 hours of training with myself.
Now, moving on to Springs Park as a company, has Springs Park ever had any lawsuit against it before?
Not before this
Objection,
case.
Your Honor. Improper character evidence under Rule 404A may be heard. Your Honor, this testimony, I expect the witness is going to testify that Springs Park, in fact, has not had any prior lawsuits filed against them. Your Honor, I would contend that this is evidence attempting to prove Springs Park's character trait, the character trait of their employees, that because they hadn't had any lawsuits filed against them, it was because they'd acted safely in the past. And because they acted safely in the past, they'd have been more likely to act safely on April 22nd. Your Honor, that's improper under Rule 404A.
Your Honor, may I be heard? One of the elements we are trying to prove today is the standard of care at the park, and I'm only trying to establish that because Springs Park hasn't had a lawsuit against it before, that shows the standard of care being upheld at the park.
Yes, Your Honor, may be heard to that. Your Honor, this evidence shows the standard of care being upheld in the past to prove that it was more likely to have been upheld in this case. Your Honor, that's an improper purpose under Rule 404.
Your Honor, may I respond?
Yes, Your Honor.
Would you like me to restate the question?
No, that's fine. We haven't had any lawsuits before this case.
And what kind of injuries does Springs Park usually see with customers?
In the past 10 years, we've seen minor injuries, anything that can be resolved with a Band-Aid or an ice pack, and we work with the parents and guardians to resolve those issues as soon as possible.
Now, moving on to the incident at hand, how did you hear about Wade's accident?
I think it was around 4:30 in the afternoon, Jordan called me, and I immediately stopped what I was doing at the other location I was at and rushed over to do an inspection and figure out what I could do to resolve this issue.
What did your inspection find?
Well, when I did the evaluation again with Jordan, I found that everything was in order.
So what further steps did you take after your own inspection?
I wanted to get a third set of eyes with maybe some more knowledge, so that's why I contacted Bailey Parker, who I know has expertise in this kind of thing. So I called her inspection as well, and then I cooperated with the Stark family's investigation and allowed Mills Barton to come to our facility as well.
And what did Bailey Parker's investigation find?
Objection, Your Honor. Hearsay may be heard. The findings of Bailey Parker's investigation are out-of-court statements offered to prove the truth and absurd.
Your Honor, may I respond? Under Rule 801, this is not an out-of-court statement, as Bailey Parker testified to this earlier in court today.
Your Honor, may be heard as to that. Your Honor, in that case, I would ask that the witness be instructed to only testify based on what Bailey Parker has already said and not anything else.
Yes, Your Honor. So, Ms. Wilson, you heard Bailey Parker testify earlier today. What kind of things did she mention to you about at your park?
Well, similar to Jordan and I, she found that everything was in working order and was as it should have been.
Thank you. No further questions, Your Honor.
Yes, Your Honor. Before I proceed, may I inquire as to how much time we have remaining?
You have 6 minutes and 25 seconds remaining.
All right. Good evening, Ms. Wilson. Now, you were in court for the testimony of Jordan, correct?
Yes, I was.
So you heard her testify that the ITP's standards are to have 15 staff members working at your location?
Yes, according to the IATP, they recommend that we have one watcher per zone as well as a roamer. And in our park, we have 14 zones. We have 5 basketball zones, 5 foam ball pits, and then 4 dodgeball zones, and 1 larger jump zone. So that's 14 total, and then plus 1 roamer is 15 people.
So you do agree with Jordan that the IATP required you to have 15 staff members that day, correct?
That's correct.
All right, she also testified that she had scheduled 18 employees, is that correct?
Yes, but unfortunately 2 were missing, so we had 16. We had 1 in each zone, and then, as Jordan mentioned, there was someone up at the front, and then Jordan herself, so that was 16 people.
But ma'am, you are aware that you only had 14 scheduled, correct?
According to what Jordan has testified, there was 1 person per zone, 14 people, and then 1 person at the front, as well as Jordan herself, so that was 16 people.
Well, ma'am, I'm not asking about how many were required. I'm asking, as to your personal knowledge, how many were scheduled. Now, you had scheduled 14 that day, correct?
If 2 were missing and we had 16 there, if I'm doing my math correctly, that would have been 18 people scheduled.
Well, ma'am, that wasn't. Is it your testimony that you had 18 people scheduled that day?
Yes.
Now, you made a statement before coming before today.
Yes, I did.
And in that statement, you swore to tell the truth.
Yes, I did.
And you knew that you had up until today to alter that statement.
Yes.
Permission to approach with the witness's affidavit for purposes of impeachment. And let the record reflect that I am generating copies of those in counsel. I'll be referencing line 85. Permission to approach the stand. Right, ma'am, this is your affidavit.
Yes, it is.
That's your name at the top.
That's correct.
And your signature at the bottom.
Yes.
And it's a fair and accurate copy.
It looks like it, yes.
All right, I'd like you to turn to line 85 with me, if you don't mind. And let's start on line 84. Say that could you read silently while I read aloud? You say that your trampoline park, quote, has numerous staff members on hand to see our guest safety with a minimum of 14 staff working at a given time. Is that correct?
Yes, that is the minimum that I do claim. Yes.
Well, ma'am, you'd agree that nowhere else in that affidavit do you mention another number of staff scheduled for April 22nd.
I do believe I mentioned the IATP recommendation of how many we're supposed to have, which is 1 per zone, and then a roamer, which is 15 people.
But you don't mention scheduling more than 14, do you?
Not explicitly, no.
And also, you were 2 staff members short that day, weren't you?
Yes, we were, but luckily we were still meeting what was required of us. We still had 1 person in each zone, and we still had people up at the front to help guests who were coming in.
All right, well, Jordan Banner didn't actually inform you about how you were short-staffed that day, did he?
No, but seeing as we still had enough people to cover each zone, that wouldn't have been necessary.
Well, ma'am, you would have only had 12 people working that day, correct?
That is not the number I just testified.
Well, you testified that you'd have scheduled 14, correct?
That is not what I testified.
Well, ma'am, you can't point to any other number in your affidavit.
Not in my affidavit specifically, but I did just explain the number that is required for us.
And later that morning, all the safety display screens went down.
That's correct, but luckily we do have posters on the walls of our trampoline park. When we first opened, we didn't have the luxury of technology all throughout our park, so we always have those posters up for guests to see upon arrival.
But Jordan didn't call you about that either.
I don't think that would have been necessary.
All right, well, you say it wouldn't have been necessary, but if he'd called, it was actually your policy to move staff from other locations.
If she had called, then I may have moved staff from other locations, but I could tell that she could handle it, and we may have acted differently, but I trust her actions nonetheless.
And it was also your policy to curtail the number of people coming in the door?
If I had been there, maybe, but again, I wasn't there, so Jordan had more context as to how to handle the situation on that particular day.
All right, let's talk about the room where Wade Stark died. Now, you have watchers in all your rooms, right?
Yes, in every single room, we always have a watcher.
Their job is to monitor safety.
That's correct.
And enforce the rules.
Yes.
Now, your watcher in the room where Wade Stark died was someone named Tommy Kirk, right?
That's correct. You cannot be here today.
You've entered into an interesting stipulation with us. You agreed that Tommy Kirk, and I quote, has nothing more to contribute than Robin Hill or Jordan Banner.
That is what has been stipulated, yes.
Well, you weren't there at that time, were you?
As I already testified, no, I was not.
And so you can't tell us for sure how many kids were in there.
I cannot, but Jordan testified to there being enough people, the correct amount of people in each room, and seeing as Tommy Kirk has nothing else to add according to the stipulation, then that would have been the correct number of people.
And you can't testify whether rules were enforced?
I was not there that day, but I know that my staff always enforced the rules when needed.
In fact, you can't even testify as to whether your watcher was even watching.
My watchers are always watching, whether or not I am there personally.
But you can't say for sure that Tommy Kirk was watching. Your Honor, may I further to that? Your Honor, I did ask a question, but I did not receive a straight answer. My question was whether she could say for sure that Tommy Kirk was watching. She said that my watchers are always watching. Or that does not answer my question as to whether she could say for sure that it was. Yes, Your Honor. You can't say for sure whether or not wristbands were checked.
Well, wristbands are mainly checked whenever someone seems out of place. So in the case of Wade Stark, it wasn't checked, but there wouldn't have been a specific reason for him to be pulled aside and have his sleeve pulled back.
Thank you, Ms. Wilson. Your Honor, at this time, I have no further questions.
No regret, Your Honor. The defense rests.
Yes, Your Honor. They forgot that she remembers. Dakota remembers holding Wade's hand, kneeling beside his body as he took his last breath. She remembers, and she will always remember, because they forgot. They forgot to protect a child that she trusted them to protect. Good evening. My name is Becca Bainbridge, and today I stand before you proud to represent the plaintiff in today's case. Now, the law here is pretty simple. The Springs Park had a duty to maintain their facility safely and to supervise children properly. Now, if we, as the plaintiff, prove that they failed in that duty, and that failure led to Wade Stark's death, we've met our burden. So let's break down the evidence. They forgot. They forgot to defend. Now let me make your job easier, because there's at least one area where there's no real factual dispute. The waiver. You heard from Dakota Stark that she was not allowed to read her own waiver. And guess what? That testimony is uncontradicted. They forgot. They forgot to staff. When 2 employees didn't show up, what did Springs Park do? Close, limit capacity, count heads? No. They did nothing at all. They kept taking in kids, kept taking in money. They forgot. They forgot to supervise safely. Here's something incredible. Jordan Day, their manager, got right up here and she told you that she went into that 13 and up dodgeball room and she told those kids to play harder. Play harder? In a room where adults were throwing balls at children? Play harder? Moments before a grown man knocked a 12-year-old boy into a metal frame? Play harder? But it gets even worse than that. They forgot to supervise at all. The one person in that room responsible for ensuring safe play, was someone named Tommy Kirk. You heard from Robin Hill. He was just scrolling through his phone. He was not policing the activity. He was not checking the wristbands. Once again, that evidence is uncontradicted. And that leads us to their final strategy. Blaming a dead 12-year-old boy. I guess it's easy because he can't speak for himself, can he? But don't you forget for a moment, members of the jury. This is a facility built for children, marketed to children, profiting from children. Now, look, there wasn't a single thing that Wade Stark did that wasn't perfectly foreseeable to them. Wade was a child, acting like a child. They were the adults. They forgot. But she remembers. She's asking you to remember too, members of the jury. So when you go back to that door to deliberate, I ask that you remember Wade Stark and give Springs Park a verdict that they'll never forget. Thank you.
May I proceed? Your Honor, opposing counsel, and members of the jury, may it please the court. Earlier today, my co-counsel, Blair Miller, came before you and told you that risk can be mitigated, but not eradicated. And that is exactly what this case has shown. Today, the plaintiff bears the burden of proof. They had to prove that, beyond a preponderance of the evidence, or more likely than not, Springs Park's negligence led to Wade Stark's death. This means that with all the evidence presented, if you as the jury feel that the scales remain even, or that they tip even slightly in the favor of the defense, then the plaintiff has failed to meet their burden. Members of the jury, the plaintiff has failed to meet their burden of proof because they failed to see that risk can be mitigated, but not eradicated. Now, in order to prove that Springs Park's negligence led to Wade's death, the plaintiff had to prove that Springs Park was negligent, that the plaintiff experienced injury, and that negligence was the proximate cause of said injury. Members of the jury, pay attention to how the plaintiff did not even mention these elements in their closing today. That is because they cannot prove them. We are not disputing that Wade Stark or Dakota Stark were injured. However, the plaintiff has failed to prove that Springs Park was negligent, and thus failed to prove that negligence was the cause of Wade's death. The evidence has shown that Springs Park went above and beyond to create an environment as safe as humanly possible. From rigorous safety protocols to detailed staff trainings and clearly marked age-specific zones, every reasonable precaution was taken. The plaintiff attempted to impeach every witness of ours because of frivolous little details that show no dishonesty in our testimonies. Let's review the ways in which Springs Park mitigated risk. First, you heard from Jordan Banner, the facility manager of the day, who told you of the day's operations and confirmed that any identified issues that morning were unrelated to the safety inside the park. Jordan Banner ensured that even when short to staff members, every zone was still being supervised. Next, you heard from Bailey Parker, a certified safety consultant who confirmed Springs Park's compliance with ITV standards and confirms that all their safety protocols were more than sufficient in mitigating risk. Finally, you heard from Ms. Wilson, the park's owner, who told you that despite there being no national or state standards for trampoline park safety, she implemented the best possible practices at Springs Park, ensuring that they met or exceeded recommendations by the IATP. And while Ms. Wilson called on an expert witness, an expert safety consultant, Bailey Parker, the plaintiff called on an expert witness who was a medical doctor with no experience of trampoline parks other than an article that she wrote. Now, the plaintiff wants you to believe that Springs Park forgot their duty of care and forgot some of their safety protocols. But members of the jury, Springs Park did nothing but remember. The evidence has shown that we took every reasonable step to mitigate risk. But risk can never be eradicated.
even in the safest of environments, especially when guests are intentionally seeking to evade the established safety protocols. According to the case Lesser versus Wildwood, camp supervisors may not be held liable if a child under their care intentionally seeks to evade that care. Robin Hill admitted to intentionally breaking rules at trampoline parks, often, both at Springs Parks and at other parks. He also told you that Wade was playing on the back of the trampoline mats, which was also a violation of the rules. I submit to you that Wade and Robin were intentionally seeking to evade the established safety protocols. Now, members of the jury, we are here today because a young life was tragically lost. But Springs Park is not responsible for this tragedy. The plaintiff has failed to meet their burden of proof that, beyond a preponderance of the evidence, Springs Park's negligence led to Wade Stark's death. The evidence has shown that Springs Park took every reasonable step to mitigate risk. But risk can never be eradicated. For these reasons, I ask that you find Springs Park not liable of negligence in regards to the wrongful death of Wade Stark.
Permission to proceed with rebuttal?
Now, my opposing counsel has told you that risk can be mitigated. Members of the jury, I agree. But as you've heard today, Springs Park didn't even do that. They let a 12-year-old sign his own waiver. They refused to let Dakota Stark even read hers. Their own manager was encouraging harder play. As far as we know, their own watchers weren't even doing their job. Sure, members of the jury, risk can be mitigated. It could have been on April 22nd, but it wasn't because they forgot. Fine for the plaintiff. Thank you.
No, Your Honor. No, Your Honor.
We're going to do the Star Awards real quick.
Okay, so for our star attorney, we chose Ayman Nether. And then for our star witness, we did Theo Goldberg. And then for the plaintiff star attorney, we did Daisy Gabriel. And then for the star witness, Madeline O'Brien. All right, that's it.
Oh, yeah.
Always are encouraged Cyrus. You have an amazing field of judges that allow them to introduce themselves and also to provide judges.
Give it again.
Introduce yourself. Tell us a little bit about you.
Right, I'm Marcy Armstrong. I am a family law specialist, and I am from Johnston County, just across the line, small community, and also past president of the law. And so I'm sitting there listening to all of you, and I'm thinking, what is the word? What word? And I came up with just one, but I came up with exceptional and courageous. I don't want to go against any of you guys. I've been practicing 42 years, so I mean, I hope I retire before y'all get out, so I have to find myself sitting on the other table. And courageous. I mean, to come before the Chief Justice of the Supreme Court, it can be pretty scary. She's a great hot guy, actually. But you think about it, I mean, at your age to do that, I mean, warriors like me that have been practicing forever, go in front of Chief Justice and shaking my boots. Just come out here and like, well, this is another guy. You guys are really very, very, very good. It's hard to, I know you need constructive criticism. It's hard to do that when you're so good and you're so exceptional. One thing I would say, I guess, with opening statements is to try not to do your closing argument in your opening statements. Just try to forecast the evidence, how they do national and wherever you're there. So just keep that in mind. Closings are great, your openings are great, your directs, your crosses, and everything. Also, I would just encourage you to be who you are. Don't be something you're not. Yourself, personality. Don't be afraid to, like I'm walking up, if you're allowed to do that, I'm not sure what the rules are, but just be yourself, your personality, genuine.
Okay, I cannot help it when there's a lot of distractions outside the window. I heard a screeching sound from a car, then I heard somebody scream, and then all these ambulance and police officers came up, and it was doing somebody's cross-examination, and all of that racket went on. But I wrote down a lot of notes, so I did not lose my attention to what you were doing. My name is Quan Bridges. I'm from Granville County, Oxford. Been practicing or been in law 40-some years. Former public defender, prosecutor, and judge. And all I can say is every time I come here, I think I've seen the best teams. And then y'all show up. And I can only imagine what the other teams were like that you beat. I mean, really, with the skill level that y'all showed, I know that there were a lot of teams that did well this week. And, I like the theories, mitigation, eradicate. I like, they forgot, she remembers. Those were great theories. And I appreciate the skill level with the opening and closing arguments. Sometimes when folks were standing here, I was wanting you to come closer. And then when you got close, I could see your eyes. And I could hear the compassion that you were making your argument. So, I don't know, to each his own. But stay close to the jury. Look them in the eyes when you're making the argument, because we listen. When you're there and you're trying to get across your point. Teams. I think think that's the most significant thing. You know, the ones that seem like teams end up up top. So the witnesses that you have on your teams, I hope that you understand that your performance is graded by all of you. You know, sometimes, believe it or not, witnesses bring the team across the line. Not to say that y'all aren't good lawyers, but we saw some performances by witnesses that I think may have made a difference. I just want to let you know you're both good teams. Whoever came out winner, you're going to represent us. Thank you.
I'll go. My name's Nisha Patel. I wear a few different hats. I'm president of the Regional Bar Association and family law attorney there. And I also serve on the North Carolina State Bar Council and the North Carolina Mock Trial Board. And so I've been participating in judging and scoring for regionals over in High Point for well over 10 years, coming into state finals, getting to see the best of the best that we have in North Carolina, and truly every year, same thing, every year I am just blown away with how amazing everyone is, and I hope a lot of y'all become lawyers, because you are truly, truly so talented. I just, I wanted to reiterate the point the judge made about coming close to the jury. At first I made a note, when we're talking about a dead child, a child who's died, where's the emotion or empathy? And once you were closer, I could really see it in your facial expression, your body language, and it really kind of tipped things over. And the thing that stood out to me the most, I would just say, the closing, I wrote goosebumps. Literally, both teams did such an amazing job with handling the witnesses and cross-examination and the plethora of objections, whether they were to kill the momentum of the other side or really, a true objection. However you use it, those were really, really effective, and you guys did such a good job of thinking on your toes. And as an attorney who does, do trial work, that's what it's all about. You have to be on your toes. And so I was really, really impressed with how everyone handled those objections and making that connection with the jury during closing. So thank you, and can't wait to see who's going to represent North Carolina in the next.
Hello, I'm Courtney Craig. I'm a civil rights lawyer here in Raleigh. It's a wonderful thing every year to come and see this. I want to thank everybody in the back row here too that support the team of families that supported your kids coming to school. I don't have very much to add. This case brought back my own cases. So I represented a mother whose child died in a rafting accident in Western North Carolina. She was 16, and there was also a labor issue. This rafting company had all these people who were underage signing waivers. And that was an issue. So it struck me, brought that home. The other thing that brought that home is we had some wonderful witnesses. And Mom here, Mom touched us, that touched us deeply. And that's and so the whole lineup of witnesses are something to celebrate. then finally our owner came through at the end, unflappable under cross-examination, which is difficult. It was a very, very good cross, and a tough, a tough one to go after. I thought coming back on the final argument on the, wrapping up was just right. You had that opportunity to come back, and you took it, and you did it in very succinctly, like 30 seconds. Boom. And that's, you get the last word. That's and another thing I liked was the movement around the court of the lawyers. It's a really nice thing to see, being able to be mobile here and then also occupying space like you did, like Mrs. Boom, when it comes time to pause and just take hold, you're going to stop facing. And it was a great combination of that. Thank
I'm going to try to get my hand moving. My name is Jim Perry. I'm from Kinston. I'm a small town lawyer. Some 45 years there. I also have the privilege of being an executive director of the Chief Justice Commission on Professionalism. And I can't really add too much to what has been said with all the superlatives for each of you. How many of y'all want to be lawyers?
Come on, everybody.
This was a case that y'all got in a packet, but there are thousands and thousands of folks that need to be lawyers. Kind of down where I'm from, there are counties down there with 10,000 people and one lawyer. Here in Raleigh, there's a lawyer for every 157 people. As attorneys, we're called to be what you all already know how to do, and that is to be zealous but honorable advocates, to be officers of the court. But we are also called to be public citizens who care about the administration of justice and access to justice. And our hope and literal prayer is that you will consider coming and serving and remember the third column attorney and really come and help folks who need you. Such a man. And I would love to tell you lots of stories about that all of us know, but don't forget why you want to be a lawyer and help your state.
Let me just say a few remarks. Folks, the panel of judges that y'all had could not be more representative of practitioners. We are very, very blessed. Great lawyers. Three of us were actually in law school together. I'm not going to say the only comment that I would have substantively is think about, is this line of questioning really hurting? Yeah, it may be a little bit outside the bounds, or I might be able to get an objection sustained. What are you gaining by it versus what harm? And as Patel alluded to, sometimes you object, just seems like a big time to object, and kind of slows down the flow a little bit. But generally speaking, particularly for what y'all again, the judges are looking, where's the meat, where's the substance of the objection? And was it well articulated, well debated, and I'll say both sides did a great job articulating the objections. But at the end of the day, you ask yourself, okay, what's the purpose? So be sure you're doing that. I used to teach trial advocacy for the U.S. Department of Justice before I went on the court in 2004. I was an assistant U.S. attorney for about 20 years. And, what we taught is exactly what y'all did. We had the theories of the case, themes that you referred to. And when you were cross-examining, you were trying to get the jurors to look at you and not the witness, and trying to get the witness to look away from the jury. It didn't work, but you tried, all right? You were well trained. You were well trained, but the witnesses were well trained. So they would listen, and then they turn to the jury. So, there's nothing much you can do about that. Maybe try moving around a little bit, try to get the witnesses' attention a little bit more. Y'all handle that so well. The fundamentals of presenting a case just so well done. But let me say this in general. I have grave concern about civic education in general. It's said that more people know the names of the three stooges than the three branches of government. Okay? I mean, we have our challenges. Our jury system is, I get to talk to judges and lawyers from all over the world, and our jury system is in of the world. And yet, so many times, people will call me up and say, hey, I got a jury summons. Can you help me get out of it? Like, let's take a minute and talk about that. What percentage of the world have jury trials? 2%. What percentage of the world have judge trials? 90%. Where's the corruption? It's in the 90%. Isn't it good to take power from the judge and give it to we people, let the people decide? I have no doubt that each one of you who participate in this program are going to be our civic leaders of tomorrow. I have no doubt about it. You're going to be the foreman or persons of the juries that we have. You're going to be the ones running for city council. You're going to be the ones that will be state and federal representatives and judges. And as Mr. Perry was talking about, we need y'all. We need lawyers, particularly 48 out of North Carolina's 100 counties don't have that attorney. Folks have legal needs that are going unmet. And we need y'all. So if you want to serve, if you want to serve in a way that makes a meaningful difference as a young person, you go to one of those 48 counties and be a lawyer. And you will continue to become a citizen. But we just applaud y'all. And now I'm going to have to ask somebody what I'm supposed to do. I have to admit that I'm really struggling. One of the things that falls on me is to determine in the final round the best attorneys and the best witnesses. And generally speaking, that has not been too difficult. And not that I would in any ways shirk my responsibility, but I did hold the jury. Okay, I did seek advice because y'all are also good. The witnesses were very compelling. Okay, whether it was with the plaintiff, defense, the same thing with the attorneys. Yes. But moving quickly to best witness, I went back and forth, and that what judge is supposed to do, scales of justice, going back and forth, but it ends up being Sydney.
also thank you once again for your parents, you guys. I know you're not here to listen. You got enough things to do. Just want to remind you how special you are. Unfortunately, this is not soccer. It's not the Olympics. So we don't get to have time. It's just the way it works. Okay. But remind you how special you are. 92 teams in this state only did this. Only did this case twice. Another 12 teams got to do it. Another 10 teams got to do it, including you, 6 times. And then you guys got to do it 7. That's really a big deal. Your dedication to March Trial. We really appreciate it. Okay. This year we've got something a little different. We've got medals. So we're going to announce the runner-up first. I'd like the coach for the runner-up to come up here, and I'd like for you to award your team members. And every member on the team gets a medal, whether they actually participated in this trial or not. So I've got one coach here, and I'm looking very smart. Coach, gotcha. Okay, you guys got it. Okay, here we go. So you know the tradition is we announce the runner-up first. This year's runner-up for North Carolina State Finals Championship round is Wake Young Women's Leadership Academy. Stay up here for a picture. Yes, please. To the last, John, to the last. Dan, you get one as well. Then there's 2 more.
Well done.
And now for our 2025 state champions, Central Carolina Homeschoolers.
Sorry, bigger business. We have that problem. It might work. Put it on there. There you go.